Thank you very much, Katrina. Labdien. Good afternoon, everyone. We are Valentijn De Boe and Joren Vuylsteke. We are lawyers with Loyens Loeff. We are part of our international energy and infrastructure team, and in that capacity, we were working together with Sorainen last year on the closing of the Kekava bypass PPP. That was a very nice experience, and we hope there will be many after that. Now we are very happy that we've been asked to join this webinar this afternoon. We are going to talk to you about a subject that is very or is an interesting aspect of lobbying, and that is how can you use complaints to the European Commission as part of your lobby campaign. Now, what do we have on the menu for today? Well, we're going to start with a short introduction on what this could actually mean for you. We have some examples, that how or situations where a complaint to the European Commission could be useful when you are lobbying your national government. These are purely hypothetical examples, of course. There's no resemblance to any real life situations. We're going to then show you a little bit of theory about what is exactly the complaint process, what is the purpose of it, and what are the different steps. And then we're going to end with some points of attention, some things, do's and don'ts, when using this as a tool in your lobby campaign. So how to make the EU or the European Commission your ally in your lobbying campaign? I think first of all, I think many of you are working in companies that are part of regulated industries, and you all know very well how political and regulatory risks affect the success of your business, and therefore anticipating and managing these risks is really key for your businesses. Now, when you are, that means, of course, that you will need to engage with the political sphere and authorities. And when you are in a lobby campaign, you can always use, or you can use the involvement of the European Commission. They can be a very powerful ally, but only, of course, if you understand well their role, and if you take care that this is done at the right time and at the right occasion. What you also need to be aware is that lobbying is regulated both at the EU level, but also in various member states, and I assume that Latvia will be no exception to this. Lobbying is, of course, still seen by the public as something, quote, dirty or something suspicious at least. That is definitely not the case, but one of the important aspects of lobbying is that it must be done in a transparent way, of course. That's why there are these rules, and there are significant legal and reputational risks if you get this wrong. Now, complaints to the European Commission, in our view, are generally a safe bet. There are various reasons for it. There's a little formalism involved, low costs. It's basically a complaint form and a good preparation, but it's a flexible procedure. There are many opportunities to steer the procedure in the right direction, to add elements or even to withdraw. And it can be done in parallel to your national actions. However, and my colleague Joren will go further or deeper into that, you need to be mindful of timing, because of course the European Union or the European Commission will only act if they feel that you have done or taken the right steps already at national level. And very important, when using this as an instrument, you need to be aware that unless in some specific cases, the European Commission is not forced to act upon a claim. So I will then now hand over to my colleague Joren, who will show you a couple of examples where a complaint to the European Commission has been useful in the past.
Thank you, Valentijn. Indeed, before we discuss the process of these complaints, it's good to have an idea of which type of examples that are taken. It could be where it could be useful to consider a complaint before the European Commission. And the first examples, if the slide will, yeah, it works. The first example is a situation where a sector federation receives complaints of undertakings within its sector. In this example, the cleaning sector, about an obligation to notify authorities before performing its activities. So if it concerns an administrative burden for these undertakings, one could consider that the administrative burden could be disproportionate and in violation of EU law, and therefore it would be useful to first interact with the national authorities and the national ministers or governments to ask to change the provision. I do not know, I do not see my screen any longer, so I do not know if that's also the case at the other side. Yeah, I see it again. And so if at national level, these contacts are not leading to any success or any changes, one could consider to file a complaint. And another example is when there is an obligation by the national law to for real estate developers to guarantee to give some financial guarantees that are not obliged to give by others, and you could consider this as a discrimination. So in this specific example, real estate developers were obliged to guarantee the buyers of new buildings either the full completion of the building, or they had to reimburse the amounts that were paid by the buyer. So the buyer was not anymore obliged to buy the building in question, whereas others were not obliged. So registered contractors were not obliged to give those financial guarantees. This is a typical situation where you could consider, after lobbying with national governments, to consider a complaint with the Commission. Another example is a complaint of a civil servant because it receives less remuneration or lower remuneration than its colleagues because it has another statute. If this could also be in violation of EU law, and therefore a complaint could also be considered if national, on that national level, there is no result of any contacts you have with the authorities. And lastly, another example that is used, or another sort of complaint that is often used to move things, is a state aid complaint. It's a specific form of complaint. In this example, this is a real life example, which is a public example. It's a complaint of an advertisement company because it's found out that a certain concession agreement that was performed out by its competitor was undergoing certain changes, and it considered that these changes were unlawful because they were in favor of its competitor, and so it filed a complaint for state aid. Then going to the process, or maybe just to highlight, before going to the process, to highlight the different sorts of situations where a complaint could be useful. It's not only when there is an obligation in national law, but also if there is a certain practice in at national level by the authorities. And not only if it's an obligation, but also where there is a deprivation of benefits, or where you consider that a benefit of another party is discriminatory for you. Going to the process of complaints, we should make a distinction between the general complaint for breach of EU law, which is kind of an all catch-all complaint form, and the other types of specific complaints. The most known specific type of complaints are state aid complaints and antitrust complaints. And when we briefly look into the process of a breach of EU law complaint, it's in fact any type of complaint for an infringement of EU law. So national law or a national practice, which in your view could be in breach of EU law. Well, that could be a situation where you think about where you can complain and you submit a complaint. It must be the standard complaint form that is on the website of the Commission. And in that complaint, two important parts must be filled out. The first one is the explanation of why there is an infringement of EU law, and the second one, and that's very important, is the explanation of which previous actions you have taken. These can be court proceedings, but can also be other types of actions contacting the authorities in question, notably. And going further, as these type of complaints, they are usually dealt with within a period of 12 months. It's not described by law, but it's an estimation. It's the Commission that commits itself to make a decision about the complaint within 12 months, but that can again be extended. And the final outcome will be either a dismissal of the complaint or a formal infringement proceeding. And another type of complaint form is a state aid complaint, which is regulated in the state aid regulation, and it exists. It also starts with a complaint form, which must be filled out, which is also a model form, and then a first phase, a preliminary investigation, where the Commission considered whether there are any doubts, whether or not there is a incompatibility with state aid rules. And if it considers that it is the case, it will start an in-depth investigation, and eventually it will take a decision on whether or not there is incompatible state aid. If there is, the outcome will be, in general, that there is a recovery decision, whereby the Commission will ask the member states to recover the state aid measure, so the funds that has been given in violation of EU state aid law. The timing of it all depends on the complexity of the case and the priority objectives of the Commission. So it's very hard to tell. It can be that a certain case becomes complexer during the complaint. So there are no deadlines mentioned in the law. And just for completeness, there's also the antitrust complaint form, which will be less used in lobbying with national governments, which comes also with a model complaint form. And there again, it's the Commission that eventually decides whether or not there's a breach of antitrust law. Again, the timing will depend on the complexity and priorities. Then going back to the breach of complaint, just for completeness, important to mention that when eventually the Commission decides that there is indeed an infringement of EU law, it will start formal infringement proceedings, and this opens a dialogue between the Commission and the member states. There is already a dialogue between both prior to a formal infringement proceeding, but this one is it starts the formal dialogue, whereby first a formal notice will be sent by the Commission requesting further information, then a formal request to comply with EU law, and eventually, if there is no, if the member state does not comply, does not change the law or the practice, well, then eventually the procedure before the EU courts will start. This, the timing of each step takes at least 2 months, but can again be extended. In that phase, that formal stage of infringement proceedings, there is less room for lobbying, because it's mainly the Commission and the member states that have go back and forth So when you're the person filing the complaint has less interaction in that phase. On the other hand, in the first part of the complaint, before a formal decision is taken by the Commission, and more specifically between the submission of complaint and the decision on whether or not there is a breach, well, there is some room for interaction with the European Commission. And we made a small timeline with the most important points of interaction and the most important point for the process. And it all starts, of course, with preparation of your case. And that preparation not only entails the filling out of complaints, of the complaint form, but the prior action you have to be you have to take towards on a national level, because you will eventually have to show to the European Commission that you made efforts to change the practice, to resolve the issue of the EU law infringement before filing the complaint. If not, the Commission will consider the complaint, might consider the complaint inadmissible, because it is an issue that first has to be addressed at national level. It's not necessary that you start court proceedings, but at least you have to show you have contacted the competent authorities. Secondly, and before submitting the complaint, it's important to contact and identify to contact the Commission to identify which unit, or first which Director General is the most competent, or is the competent one to receive your complaint. And it is always advised to search the specific unit or even the contact person that will deal with your complaint before submitting your complaint. Then after submission of complaint, there is an important step, which is consistent in informing others. And it is important, of course, that you inform the local authorities that you already contacted before about the fact that you have filed that complaint, but also to inform others in a similar situation as you are, or even the sector federation to which you belong. Well, because that sector federation may also contact others in the same situation, and incite others to also file a complaint. You could also consider, before filing a complaint, to first contact your sector federation and to ask the sector federation to act on your behalf, or on behalf of several undertakings, to file the complaint. And this is all because, in fact, the Commission will give more priority or more weight to your complaint if it is not only a single complaint, but a complaint of several undertakings, or a complaint of a sector federation. And after informing others, the process of a dialogue with the Commission can start by first asking questions about the timing of proceedings, how long it will eventually take, but also asking them whether you can send additional information, whether they have all necessary information. And mostly there is not a lot of response, but it always depends on the unit in question, but the response is limited. And you can also think about sending updates, sending additional information to the Commission to keep them involved and to follow up regularly. Eventually, you could also ask for a meeting. In practice, it does not happen a lot that you are invited to a meeting, at least not before there is a formal position of the Commission. So what happens in complaints is that, especially complaints for breach of EU law, is that the Commission will first take its formal position, but will not take the final decision yet. They will say, this is our position at the time being. Do you have any reaction to that? And at that time, it's the most crucial one in the entire timeline. It's important to react within the time frame given, and to do so by, of course, giving your counter arguments if you do not agree with the position of the Commission, but also giving them additional information and requesting for a meeting. Having requested for a meeting before their position, before receiving the formal position of the Commission, can maybe induce them to finally give you that meeting you asked for. For additional information, the same the comment is there. Yeah, try not to overload them with several emails. Try to do that in a proper manner, of course, and maybe leave some important information leave it with you, and once you have the formal position of the Commission, and then send it to the Commission so they can maybe elegantly change their view in light of additional information. It sometimes can be a good thing to keep it just at the end in order to maybe force a position. And then eventually it's the final decision of the Commission. Valentijn, you're on mute.
I was just saying thank you for this overview. I think it's indeed it's very important that when you are considering to involve the European Commission, that you think of how you can frame your requests in an EU law context. So you know that the EU is very concerned about discrimination, about freedom of services and freedom of establishment. So if you can formulate your problem as some sort of barrier to entry, to invest or to undertake business in Latvia, that will of course definitely be heard by the Commission. So there's a number of points of attention that we wanted to raise in terms of lobby regulation. So the process of lobbying doesn't happen in a legal vacuum. There are rules to take into account. There's staff rules that apply to civil servants at the Commission, so they must not, or they may not accept certain gifts, or they may not be invited to certain lavish lunches or dinners. So that's of course important, but there's also another important element that is becoming increasingly important, and that is the EU Transparency Register. So what is this? This is something that has been in existence for over 10 years. It's an online register in which entities, companies, interest representatives are invited to register themselves when they want to interact with the EU institutions, when they engage in lobbying. And the idea is that the public that thinks that lobbying is suspicious can consult that register and actually see or get more transparency on which entities are lobbying, what they are doing, and how much they are spending on lobby campaigns. Now, in the first years of its existence, it wasn't that successful. However, things changed with the previous European Commission because they imposed a number of new rules, and these rules included the fact that the top EU or the top Commission officials could no longer meet with unregistered lobbyists or with unregistered entities. So whenever there was a meeting, the top or the commissioners themselves, the heads of the directors general and the cabinets, they had to check whether the people they were meeting with were actually registered in the transparency register. And that also means that if you are not registered in the transparency register, you lack access to the top of the Commission. Now, what is considered lobbying by the transparency register? Well, it's any activities carried out by interest representatives with the objective of influencing EU policy or EU decision making. It's a very wide definition. However, and that's important for the purposes of this presentation, there is an exception for submissions as a party or as a third party in the framework of a legal or administrative procedure established by EU law. Now, the complaint procedure that we have been talking about is definitely one of these legal or administrative procedures. And when you're acting within the framework of that procedure, you can rely on this exception. However, in order to make a successful campaign, it is very useful to be able to contact the Commission already prior to submitting that complaint. So therefore, it is still interesting, important to register as a lobbyist or to work together with entities that are registered. What does this entail? Interest representatives who are registered must disclose certain information about their lobbying activities, about what they are the topics they are lobbying on, the sort of resources they use for lobbying, as in the amount of people they have involved in these activities, and also the amount of money they spend on lobbying. Important also is that registration with the EU Transparency Register is voluntary, but because of the increasing importance, it's becoming more and more difficult to make yourself heard in Brussels if you are not registered. Even if a person at a lower level in the Commission is not considered to be a top official that must only meet with registered lobbyists, that person is still in the staff rules, it's recommended that that person checks whether somebody is registered that he is meeting or she is meeting, and he or she must then for himself decide whether it's appropriate to continue the conversation. If you are interested in this topic, there's a link in the slide. Joren and I have written a chapter on do's and don'ts and how the lobby register at the EU level works exactly. So definitely go to that website. I know that there are discussions in Latvia also on how to increase transparency in lobbying. So I think it's also useful to see where these discussions could be going. But that was it for what we wanted to say about EC complaints. We would be very happy to take any questions that you may have. And in any event, we're very grateful for Sorainen to have invited us to give this presentation. So, paldies.